members to see whether the case do fall within the ambit of 184(3) or not. The litigant would be invited to argue, or that would be only seen by the members of the committee themselves. If 2 out of 3 comes to the conclusion that it is not a case fit for to proceed with Article 184(3), would it not be defiance of right of audience and the Article 10A and all other due process?
In continuation, and what remedy would be available to him, because this is an administrative order, they cannot be challenged in appeal except the chamber appeal under the rules.
Mr. Attorney General, Section 3 is not actually saying that he's going to dismiss a petition at the administrative side. It is simply saying we look at the petition as the Chief Justice looks at the petition. He looks at it, it says a 184(3) petition, he marks it to a bench. It is not saying there is no consequence. Suppose he thinks there is no question, he'll mark it to some other bench. It doesn't say he'll dismiss the petition as to give a hearing to anybody. This is just to look at the
My lord, ये जो threshold है administrative side पे day in day out basis पे हमें cross करना पड़ता है litigants on this side. जहाँ पे objection आ जाते हैं registrar के कि ये meet नहीं.
What's been happening? Number of 184(3) petitions have come up that the office has put objections. Yes. Not the judge, the office.
Yes.
जी one very low. बिल्कुल. ठीक है, उन्होंने objection लगा दी. Not does not come within a parameter.
chamber appeal में जाना पड़ता है.
They've come to me some of the absolutely ridiculous kind of petitions. ठीक है, they are dismissed in my chamber against an appeal is filed. The fact that you don't make available 184(3) does not mean you can't file a civil suit, does not mean you can't file an FIR, does not mean you can't go to 199, does not mean any other remedy. So this is done every day, we do it. Not 3 judges, 1 assistant registrar in the branch office says not maintainable, उसके खिलाफ अपील आती है. वो कितने लोग सुनते हैं? 1 जज. उसके खिलाफ क्या अपील है? कुछ भी नहीं है. End of story. ठीक है, तो यहाँ वो भी जुरिडिक्शन बढ़ गया है. वो आपने हमें वो असिस्टेंट रजिस्ट्रार के पास हमें दे दिए हैं, उसके पास होना चाहिए असिस्टेंट रजिस्ट्रार के पास, तो रहने दें उसके पास, वो बेशक बेहतर तयन कर लेगा. जो खुश नहीं होगा वो अपील में होगा. अब तो ये तो बल्कि ज्यादा उसको अहमियत दी जा रही है रादर देन उसको निगेट कर रहे हैं. और राइट तो नहीं है 184(3) का. राइट आपके सारे महफूज हैं, जो आइन देता है, जो कानून देता है. ये नहीं कि आपने 184(3) की पिटीशन डिसमिस कर दी, 99 में आप नहीं जा सकते हैं, या आप सूट नहीं फाइल कर सकते हैं, जो भी चीज. यहाँ तो लोग अजीब अजीब चीजें, जी मेरा इससे पैसे उधार हैं, वो जाके 184 डाल दिया उसने, हमने उसको डिसमिस कर दी. रजिस्ट्रार ने राइटली मेंटेनेबिलिटी भी किया, अपील है, हमने उसको डिसमिस कर दिया. इवन दो जस्ट वेस्टेड अननेसेसरी टाइम ऑफ अ जज ऑफ द एंटायर स्ट्रक्चर ऑफ द सुप्रीम कोर्ट. तो आई डोंट नो what are we taking away? Back to the same question, what are we taking away?
इसमें इस वक्त क्या सिस्टम चल रहा है? 184(3) में सिस्टम क्या चल रहा है?
2 सिस्टम्स हैं. एक है कि जब कोई पिटीशन आती है, जब कोई पिटीशन फाइल होती है तो वो ऑफिस के इससे होके जाती है. रजिस्ट्रार ऑफिस वुड फर्स्ट एग्जामिन वेदर इट मीट्स द थ्रेशोल्ड और नॉट. इनफैक्ट उसके ऊपर जो ऑब्जेक्शंस आते हैं वो कहते हैं कि ये नहीं मीट करता, एंड दैट्स द एंड ऑफ द मैटर. यू फाइल अ चेंबर अपील. सो दैट इज वन राउट. 184(3) का दूसरा है सुओ मोटो. नाउ this provision in fact cures the problems in the process on both counts. First, 184(3) की जो registrar ये power exercise कर रहा था, that power has now been given to this committee, the 3 senior most Chief Justice and 2 senior most judges.
You see, the power of registrar could be appealed in chamber, but in 3 members committee where the appeal lies.
It is the 3 judges, my lord.
3 judges.
ये बात ठीक है कि उसमें ये बात हो सकती है कि जी उसकी कोई आपको जो है वो आगे हेयरिंग नहीं होगी, हेयरिंग नहीं होगी. मगर
जी साहब आप ये बता देना कि अगर 2 जजेस या 3 जजेस बेंच चल रहा है, जैसे कि पुराना सिस्टम है, उसमें एक अगर 3 मेंबर समझते हैं कि दिस इज केस ऑफ पब्लिक इंपॉर्टेंस, वो रेफर करते हैं ऑनरेबल चीफ जस्टिस को, और चीफ जस्टिस इनकार कर जाता है कि तीनों से एग्री नहीं करता. ही हैज ऑल द पावर, तो सिर्फ 2 मोर पावर. 3 judges sitting in the court. The Chief Justice alone sitting in a chamber can undo this.
And the suo moto particularly, उसमें तो और ज्यादा फिर problematic है, because उसमें तो खुद ही कर रहे हैं, वो खुद ही examine कर रहे हैं.
3 में भी the process is that if the committee thinks that it's a matter of 184(3), they'll mark it to a bench which is not less than 3. If they think it's not, they'll send it to a 2-member bench maybe or whatever. The It's not throwing out the list.
And my lord, as
objection to the effect, and that is for us internally to provide an appeal against
my lords
that
can
order.
suitably amend the rules and
See,
perhaps
again,
provide an appeal.
the question is that since 1980 had not amended our rules, that is why the Parliament was forced to amend them. Had we amended them ourselves, because the bars were raising questions, the public was raising questions, the litigants were raising questions, we actually forced the Parliament to do it for us. And everyone, there's consensus that this is exactly, अब इस वक्त हम सिर्फ ये कह रहे हैं कि बहुत अच्छा काम है, पार्लियामेंट ना करती आप कर लेते. But what when we are refusing to do that? And that is exactly what has happened.
Being 43 years.
This act simply says that we've not been doing our job earlier.
That is it.
And it's saying we'll do it for you because you've been sleeping all this.
You are too polite to say that.
My lord, we have section 4.
Read that. Actually.
Section 5.
अभी तक जवाब नहीं आया.
जी, वो आपने जो बात कही कि जी अब फुल कोर्ट अगर बैठेगी उसमें उस राइट ऑफ अपील का क्या होगा?
पहले क्वेश्चन तो ये है कि राइट ऑफ अपील कॉन्स्टिट्यूशनल अमेंडमेंट के बगैर कैसे आ सकती है जब 184(3) is a constitutional provision and it specifically it does not provide a right of appeal. Where the right of appeal was sought to be provided, it was provided specifically in the constitution. So aren't you adding to the constitution or amending the constitution without an amendment in the constitution?
Entry 55 says that we'll enhance your jurisdiction तो उन्होंने एक और 84 की अपील बना दी है. तो enhance
185 की भी फिर एक और अपील बन सकती है.
बना दें.
बन सकती है. सेकंड अपील तो है, हमें वैसे भी बताया.
Speaking for myself, Learned Attorney General, speaking for myself.
Why not then a third appeal or a fourth appeal or a fifth appeal?
It's the Parliament. Parliament won't do absurd things, and of course,
it's not a question of absurdity because this undercuts the review, the whole concept of review. The finality of judgments for res judicata is regarded as one of the most fundamental principles of the administration of justice.
it surely does.
Exception, no. अगर आप बात कर रहे हैं तो ये तो फिर infinity हो गया.
नहीं, infinity नहीं है. Obviously, we're talking about the Parliament here. We're not talking about.
आप बात फिर आ जाती है conjecture और theory और ये और वो. बात principle की हो रही है, असूल समझने की है ना. एक दफा एक बात को concede कर दिया जाए, accept कर लिया जाए. In principle, then there is no limit. And therefore, if there is no limit, the question to my mind arises that therefore the power does not exist.
My lord,
this is the
great
point.
respect.
लेकिन ना review jurisdiction भी है ना. Review jurisdiction का क्या concept है कि Supreme Court में finality हो गई. अब आप maximum में review करने की.
With great respect, when it comes to even on this plane, even on this plane, and I submit that entry 55 sufficiently covers section 5.
Can you go to the next point?
Ji.
I'll only add to this, Learned General, there's a distinction. Article 185 explicitly is for those judgments that are rendered by the lower courts. Here the appeal has been provided
184.
In 184(3), which is our original jurisdiction, and it's only of a supplemental nature. It's a continuation of the same proceedings, the original jurisdiction.
And in a context where this court becomes the first and the final court in the same proceedings.
Are you done?
My Lord, to this extent, and I'm just going to conclude my other two submissions here. I have placed on with my paper book the judgments of in Baz Mohammad Kakad case and the Punjab Provincial Cooperatives case. They are in volume 2, my Lord. My Lord, section 6 now, right to...
there was one concern also expressed by Justice Aisha Malik, which was that if we follow this procedure, then when the full court meets, then the appeal goes away. एक ये भी point था, इसको आप कैसे address करेंगे? Because I mean, one answer could be कि if the wisdom of all is such है, तो फिर वो naturally सब लोगों ने सारे एंगल देखे होंगे, एड्रेस करना चाहते हैं.
उसमें एक ये बात है, मैंने अपने रिटन सबमिशंस में ये कहा है कि आप इसको टू दैट एक्सटेंट रीड डाउन कर लेंगे.
इस हद तक रीड डाउन करें
जहाँ पे फुल कोर्ट होगी, नेचुरली अपील हो जाएगा, बट आप उसको ये कर सकते हैं. सॉरी सर, just
I'm saying if you harmonize 4 and 5 in a situation where the whole full court is hearing it, the question of appeal does not arise.
My Lord, ये अब 15 बैठे हुए, so मैं जैसे so if it was in original proceedings, it was a bench comprising of 7 lordships on this side, the appeal would have come before the remainder 8 judges, because it had to be a bench larger than the bench hearing the original appeals. In this case, we are before your lordships in original jurisdiction, full court.
आप देखिए ना, इसमें ये जरूरी नहीं है कि one jumps from 5 member to full court. अभी 15 जज हैं, ठीक है ना. फर्ज करें एक आर्टिकल 184(3) की जजमेंट वो पिटीशन आ जाती है, 9 मेंबर बेंच बन जाता है. फुल कोर्ट तो नहीं है.
माय लॉर्ड वुड बी माइंडफुल. बात सुन,
ये हो सकता है आप कहते हैं यहाँ पे जी वो चीफ जस्टिस मास्टर ऑफ द रोस्टर है, तो ये खराब और वो खराब और ये खराब. फर्ज करें 3 मेंबर कमेटी कहती है जी हम भी उसमें बैठ सकते हैं, हम राइट ऑफ अपील खत्म कर देते हैं, हम 9 मेंबर बेंच बना देते हैं. आप देखिए ना, आप इसको एड्रेस कीजिए ना. ये ऐसी बात नहीं है कि जी द विजडम ऑफ द फुल कोर्ट आ गई तो राइट ऑफ अपील तो खत्म हो गया.
what I'm submitting is that now it's a ड्यूटी कास्ट हो गई है इस कमेटी के ऊपर.
अपील
पर उसी तरह ड्यूटी पहले चीफ जस्टिस पर भी थी ना. नाउ यू पुटिंग द ड्यूटी ऑन द फुल कोर्ट, तो कोर्ट तो फिर अपनी मर्जी पर ही चल रही है ना. व्हेनेवर इट वांट्स टू डू समथिंग वो राइट ब्लॉक करना चाहेगी. What you are saying is that substantive right that you have created under the statute is again left to the mercy of the court. It will decide कि ये substantive right देनी है कि नहीं. तो फिर आपने ये right दी किस मकसद के लिए?
8 member bench बन जाए, 9 member bench बन जाए, right of appeal खत्म हो गया.
So let me just
I think what we can do is we can logically interpret the legislation. Now, for instance, when this case was first heard, it was an 8-member bench. There were not enough judges, still aren't, to have heard an appeal, theoretically speaking.
Yes.
So, unless the bench, the very first day it sat, it decided to strike out this law. That's a different thing. But if it was sustainable, then how could an 8-member bench be constituted to begin with? Because that right of appeal was taken away from day one the bench sat. We are now worried about the right of appeal when there is a full court, but this question should have been raised against those, or when the bench was being constituted, that the law provides for a right of appeal. Here we are 8 of them, there aren't 9 of us available. So how that right of appeal has already gone away. We have decided an important component of this law. Before sitting in the courtroom, we have decided it. Is that correct?
Yes.
So when we are concerned now, we should have been concerned earlier too. So वो तो गई.
Actually जब वो CMAs थी फुल कोर्ट के लिए जब आर्ग्यू हो रही थी, तो उस वक्त ये सवाल बकायदा उठाया गया कि आप कह रहे हैं फुल कोर्ट बनाई जाए, आपको तो कहना ही नहीं चाहिए कि फुल कोर्ट बनाई जाए, आपको तो कहना चाहिए this matter should be heard by lesser number. वो CMA की वो hearing पे नहीं गई,
but the burden at the end of the day was on us.
The question was in fact put by me, and so therefore it's not that the question was not there.
My Lord, if I may briefly respond to it, followed by a response in writing.
Let me add to this. Let me add. मेरे ख्याल से जो मैं गदर कर चुका हूँ और ऑर्डरशिप पढ़ने के बाद महसूस कि जब ये पिटीशन ली गई उस वक्त तो यकीनन बिल था, इट वाज नॉट थ्रू द पार्लियामेंट, एक्ट नहीं बना था, बनने से पहले सस्पेंड होता जो कि आज तक इनफील्ड नहीं है। अगर ये इनफील्ड होता तो शायद 8 मेंबर बेंच उस वक्त भी ना बनता। इसका मतलब ये कि हम एक्ट को मान रहे हैं, अगर हम बेंच पे एतराज कर रहे हैं इसका मतलब हम एक्ट को मान रहे हैं, और अगर एक्ट सस्पेंड है फिर तो अगर 8 मेंबर बन सकते, व्हाई नॉट फुल कोर्ट।
सो मैं इसका ब्रीफ एक रिस्पॉन्स दूं एंड देन फॉलोड बाय डिटेल्ड रिस्पॉन्स इन राइटिंग, ब्रीफली पुट, and that would perhaps address ladyship's question as well, but in subject to what we have to submit in writing. Going forward, if this act is declared intra vires, the committee at all times would be mindful that there is a right of appeal, a substantive right, which will get obliterated if a bench beyond a certain number, given the numerical strength of the court at a particular time, is constituted. So therefore, that power, that administrative power exercised by the bench.
Mr. Attorney General, इसका मतलब है पार्लियामेंट ने फैसला कर लिया कि जी फुल कोर्ट, सुप्रीम कोर्ट की फुल कोर्ट कभी बैठ ही नहीं सकती।
in cases, in circumstances हो सकता है, जैसे अभी भी है।
तो सोचिए आपकी बात की कि यही प्रिसाइसली सवाल है कि इस लॉ की इस सेक्शन की वजह से।
So let me put it differently.
ये
now
फुल कोर्ट कभी बैठ ही नहीं सकती।
नहीं, फुल कोर्ट आप बैठेंगे
in Article 184 questions which are the most important question that can ever be raised before the court.
In exceptional circumstances it might be so, but does that is that to just take away the right of appeal?
Attorney General, the other way to look at it is that if the committee were to have the view that the matter is so grave and so serious that a larger bench which will not provide for an appeal be made, either full court or any large bench, then that be so. I mean, that is how the committee will decide, looking at the issue. So it doesn't take away the power to constitute a larger bench or a full court, but at the same time it will be saying that it's so important that a collective wisdom will prevail. There is no, I mean, doesn't really, it can be easily
It can be reconciled.
My
lord, section 6, right to appoint.
Section 5 can be read down.
My lord, to that extent, my lords can hold that in exceptional cases and when situations this sort arises, that be so, my lord.
Right of appeal पे substantive right नहीं है, जो statute.
Ladyship, look, we are faced with a situation here, and let me just be very candid now. We have had recording, we have had car case, and we have God knows what not. And all of that has happened under 184(3). With great respect. With great respect. And steel mill is a classic example. Steel mill was in profits at the time when all of that happened, as far as my information goes. It had 12 billion worth of raw material lying there. And now we are faced with an asset which is constantly bleeding.
How many of those were full court? How many of those were full court judgments?
My lord, may not be.
यही तो मैं आपसे कह रहा हूँ ना.
Not be. मैं ये कह रहा हूँ कि इसको reconcile किया जा सकता है.
लेवल साहब, यही तो पॉइंट है कि एक तरफ आप कह रहे हैं हम राइट ऑफ अपील दे रहे हैं in order to address precisely these kinds of things. दूसरी तरफ कह रहे हैं चलो फुल कोर्ट बन जाए तो बन जाए.
फुल कोर्ट बन जाए, मैं ये कह रहा हूँ कि there might be issues in time.
आप काइंडली जरा थोड़ी सी
there might be issues in time.
Applications of your submission तो काइंडली
उसको ये इस तरह से आपको कहता हूँ कि
Attorney General साहब, we are all grown ups, right?
Attorney General साहब,
can I just the problem arose, I think thousands of articles have been written, lawyers have spoken about it. We keep talking about the two chariots, but let's place some emphasis on the lawyers also say. There has been allegations, and I can deny it, but it doesn't. Public opinion thinks that 184(3) has been misused, jurisdiction has been exceeded. Okay? So what you are saying is, first of all, we did not create the mess. You created the mess. We are trying to solve your mess. What did we do? 3-member bench judgment, 184(3), final judgment. Nothing can be done. Now we are concerned about full courts only. What about the 3-member bench judgment? It was a 3-member bench judgment which did recodic. It was not a full court or even a large bench. A 3-member bench is the normal, smallest bench in the Supreme Court. So what could you do? Nothing. Now you come in advisory jurisdiction. We have to kind of find ways and means, because it's the interest of the country at stake. I would rather surrender my high status and at the feet of the taxpayer public of Pakistan rather than give them a whopping liability of $6.5 billion because the independence of the judiciary, they'll say, what are you talking about independence of judiciary? Independence of Pakistan will disappear if you labor this much of debt on Pakistan, 6.5 billion. It's not easy, we don't understand the repercussion of things. Fine, I'm not saying that judges who decided that they did what they thought, time, how they were assisted according to their conscience correctly in their minds. Yes, but we make mistakes. Suppose I was a member of this bench. I would love this thing if it came to my mind, repercussions. Okay, now there's a right of appeal. I can undo. Review jurisdiction, you know what the review jurisdiction is. Take the case of Zulfikar Ali Bhutto.
Yes.
Supreme Court split. Review unanimous because the scope of review is very different creature. It is error floating on the record, so they didn't even go there. That could not be rectified through review. You had to create 184.3. If आपको simple बोलना चाहिए, अगर आप अपने इतने ज्यादा काम ना करें, थोड़े हदूद में रहें, शायद हमें इस लेजिस्लेशन की भी जरूरत नहीं पड़ती. हमने भी तो थोड़ी गलतियां कर ली. हमें देखिए हमारा प्रॉब्लम ये हो गया ना, बड़ी बन गई है और तकब्बुर. हमसे गलतियां हुई हैं, मुझसे गलतियां हुई हैं, मान लें गलतियां हुई हैं, ठीक है. हमने ऐसी ऐसी चीजें की हैं, हमने जस्टिफाई किए मिलिट्री टेक ओवर्स को, मान ले गलती की है, ठीक है. अदरवाइज आइन की कोई हैसियत नहीं है. अगर जजमेंट लॉ हम उसको रख लेंगे अपने ऊपर, तो वो तो फिर आइन तो गया, फिर वो तो सारे जजेस थे, उन्होंने सबने एंडोर्स कर दिया. मैं नहीं मानूंगा इसको क्योंकि मैंने हल्फ नहीं उठाया है. द मिनट आई से दैट प्लीज फाइल अ against me that I'm violating my oath of office if I say even this, कि I will endorse these subsequent acts. तो हमें मुल्क का भी तो सोचना चाहिए. हमें अपनी सिर्फ अपनी अना और आपको अना और इन ख्वाजा साहब मुझे नहीं पता उनको क्या मसला हो रहा है, उनको हमारा फिक्र पड़िए. हम स्यूमोटो हर जगह करते हैं, हमने यहाँ क्यों नहीं स्यूमोटो किया? Why are we waiting for him to bring an act? 10 petitions आ गई, पब्लिक में से तो कोई नहीं आ रहा है. पता क्या मसला है लोगों का? उनके तो कोई मसले नहीं. वो कहते हैं हमारा केस चला के. Sorry, I'm diverging, but we have to see the larger picture also. We have to see work within the constitution where every citizen gets his due. But what are we doing? What are we taking away from him? Focus on that.
Nothing, my lord. And section 6, my lord.
इसमें Attorney General साहब Law Reforms Ordinance के तहत there's a right of appeal. लेकिन कई cases में, depending on the issues, the high courts constitute larger benches, and therefore that right of appeal is not availed. लेकिन जहाँ तक देखें ना, जो अभी बात हुई है 184.3 is discretionary. Now यहाँ पे जितनी बात हुई है, even the petitioners, their counsels, they all agree that this law is in the interest of the litigants. It actually enhances access to justice. So why shouldn't we just not exercise our jurisdiction? Because in exercising jurisdiction, we will be going against the interests of the litigants. Why should we go against the rights of the litigants? It is in their interest and in their favor.
एक प्रॉब्लम अभी जो अपील के बारे में बात हो रही है, कॉन्स्टिट्यूशन हैज आंसर टू इट. सपोज आज हम 15 बैठे हैं, कल 2 वैकेंसीज है वो भी फिलअप होती है, 17 के 17 बैठते हैं. इशू यहाँ पे ये कि अपील की रेमेडी नहीं हो, इस एक्ट के तहत अवेलेबल नहीं हो. लेकिन कॉन्स्टिट्यूशन कहता है आर्टिकल 181 में, जब ऐसी सिचुएशन आ जाए तो अ जज फ्रॉम द हाई कोर्ट कैन बी आस्क्ड टू एक्ट टेम्परेरी जज ऑफ द सुप्रीम कोर्ट. तो वो आपका एक्ट कहता है कि लार्जर बेंच विल हियर द अपील. सो एड वन जज, this is larger bench, appeal is there. No problem. I think problem is solved by the constitution.
The remaining judges would be the same.
Yes, of course.
फैसला तो वही आएगा.
This was just like review.
आपने conclude कर लिए.
My lord, I just now the section, as far as section 7 is concerned, I've already submitted. I think this provision surely addresses the concerns of the litigants, fixation of cases. under section
provision
7.
of intra-court appeal, that is to be seen. Intra-court appeal जो आपकी है, उसको देखना है.
इधर सिर्फ प्रॉब्लम ये जो आपने रिट्रोस्पेक्टिविटी दी है इस लॉ को, उससे हमारी पेंडेंसी और ज्यादा नहीं हो जाएगी.
My lord, at one end, now my lord would have
देखिए,
to see
हम सारी बात ठीक है मान लेते हैं जी, आप इंटरेस्ट कर रहे हैं, उधर आप उसको रिट्रोस्पेक्टिव, अब आप सोचिए 185(3) का और आप इस तारीख से दे रहे हैं, यू गोइंग बैक अप, व्हाट डू यू एक्सपेक्ट अस टू डू देन? We, the whole will be gutted.
How many cases would there be, my lord?
And no limitation period is
ये
here.
तो आप ना करें ना.
My lord,
ये थोड़ा
I
सा
think what has been
ख्याल रखा करें ना, आप रखिए, आप लाएं
what the parliament has,
चलो ठीक
my
है.
lord, what the parliament has tried to address here is,
You see, it is very open-ended. Prior to the commencement of this act, so it will go to 1947 or what?
जितने 185, 73 से शुरू हो जाएंगे.
my lord, 1947 तो नहीं, 75 पे पहला हुआ था.
एक बात है, अब इसमें it is open-ended ना.
And then
You have fixed a limitation of 30 days for filing appeal prior to commencement of this act. Means all previous decisions, all persons can come to this court within 30 days after the sustaining the.
I think 30 days have expired. I don't know how many came
ये
actually.
बताइए अटॉर्नी जनरल साहब,
जरा ये मालूम करें दफ्तर से कि इस इनैक्टमेंट के बाद अपील कितनी फाइल हुई है इस प्रोविजन के तहत?
वैसे नहीं हुई होगी because the law was
सस्पेंडेड. ओके ओके.
couldn't have taken effect.
फिर एक और छूट जाएगा ना. ये बताइए कितनी दफा इस कोर्ट ने मार्शल लॉज को और डिक्टेटर्स को वैलिडेट किया है? Can the people of this country file appeals and have those judgments annulled? Why not?
I would hope so.
I think this is our accountability. Let us be open about it. Why do
And my
we
lord,
fear
just
if
to-
it's
just-
Otherwise,
history,
we'll
I
be
think-
brushing things under the mat.
1975 Manzoor Alai was the first case under 183, and thereafter, after 13 years, it was Benazir Bhutto case, 1988. ज़्यादा जो jurisdiction exercise हुई है वो perhaps
But where do you
15
draw
साल
the
में
line?
हुई है.
Where do you draw the line? I mean, the question is, if there is transparency, then let it be.
Let it
Why
be.
brush something under the mat and look into some? Why?
My lord,
Let's undo Federal Shariat Court Maulvi Tamizuddin Khan case. Effectively, it won't mean anything, but maybe it will look good. I don't know. Because he's dead or whatever, long past. Go on.
my lord, I would conclude my submissions with this. I have the written submissions along with reliances. I have noted down one question जिसका detail
ये सेक्शन 6 पे भी बता दीजिए लर्नेड अटॉर्नी जनरल, ये जो आपका
right to counsel.
Yes, because it is already covered under Article 188 of the Constitution.
उसमें order 26 है.
Power of the review.
जी, order
So you
26.
have said that the party shall have the right to counsel of its own choice.
पहले जरा my lord का 188 पढ़ लें जो रेफर कर रहे हैं my lord.
188 is the Supreme Court shall
पढ़ लें जरा.
have power subject to the provisions of any act of parliament and of any rules made by the Supreme Court to review any judgment pronounced or any order made by it.
Yes.
So this power under the power of review.
काउंसिल का
Change of
प्रोविजन
counsel.
रूल में डाला गया है ना.
The order 26, rule 6. The order 26 deals with the review, the Supreme Court rules, and rule 6 is the rule where the court.
No, I am only asking about the change of counsel, why this provision has been created, because the new counsel will come and he will argue the whole case as an appeal, because you know the scope of the review. Normally the counsel who appeared originally, he came in review and we hear him. New counsel will come with new fees and with new motivation and new energy. Then he will try to argue the whole case again as an appellate jurisdiction.
And actually the wisdom...
एक second, I think my lord has made a very valid point. If I was to sit in a court, first question I would say, yes, where did you take this point in your pleadings?
Yes.
And if he hasn't, he hasn't. I mean, my
And if
answer to
there are
him
no
would be,
written
he
submissions
can't,
filed,
arguing is like arguing, but we will go by the written, you didn't take this point, खत्म जाओ भाई.
Yes.
वो रिव्यू में वो अपील का पावर नहीं हो जाएगा उसके पास.
Review नहीं grounds.
उसकी wisdom यही थी ना कि counsel, the same bench, same counsel, they
Same
would know what
settings,
transpired
same-
last time in the hearing, what questions he had agitated.
अपनी भी wisdom
My
की
lord,
wisdom.
अब जैसे for example, I am assuming that the proceedings of this courtroom are transcribed and they are, we have the transcripts desired or required. Technology can be used, but That said, if there are submissions, and obviously people file their concise statements, or they bring their petitions, file their responses, or make written submissions, nobody can go beyond that. Now, if a council, the new council comes before your lordships and make a point which is beyond the pleadings before your lordship or any written
what is the
submission
purpose
filed,
of introducing this section? Why new council? We totally
lawyers demand. मेरे ख्याल में lawyers demand थी.
क्या वो वाली बात है जो मैं
अभी वही सवाल आएगा कि what is the fundamental right which is
lawyers का demand था या किसका litigants का demand था?
philosophy क्या है इसके पीछे नए वकील को लाने की?
My lord, न्यूयॉर्क बार का जो इम्तिहान होता है तो उसमें कोई 35% हर साल में 2 दफा होता है तो फेल हो जाते हैं. जो हमारा यहाँ पे जो सिस्टम चला आ रहा है उसमें there is lot of issues, so मैं मजीद
रेशो बता दें.
बता दिया आपको.
Mr. AG साहब, towards right. 188 says subject to Act of Majlis Shura. Whether any act has been promulgated to regulate this article prior to this act. Is there any act?
My lord, there was an act, review of judgments in order to not, well, this particular provision actually was also included in that act, and a 3-member bench struck that law.
It was subsequent to this law. It was not prior to this act.
Subsequent to this, but it came decided before.
There was no act. There was no act.
No.
So the things were going on unconstitutionally.
Under Order 26.
Unconstitutionally, because the Constitution says to
act and the rules. And the rules.
Both,
so there was Order 26.
There is no or, there is and.
And.
So both must be there, act and the rules. So where is the act?
My lord, here you would read it interchangeably perhaps, but in order to protect Order 26 and the Supreme Court rules, and it was being regulated.
One question I have of a general importance. When I'm sitting in a court of law, am I bound by the Supreme Court rules? Or rules are an aid of administration of justice, and rules bind the council and the litigants but does not bind the court? What is your position on that? Am I bound to follow the rules of 1980? I mean, like for instance, Order 33 says I can condone delay, I can do various things. So it is there to be followed by litigants and council, but there may be cases of extreme injustice. We may overlook, for instance, in criminal matters, we rarely even ever dismiss things on grounds of limitation, though it is provided that it has to be filed within a certain period of time, because the liberties of the subject, we haven't given a decision on it. So, but I think rules are really to show us, guide us, not really to bind us.
Actually, rules acknowledge this. Order 33, Rule 6 actually says so.
Overall,
it says that rules shall, nothing in these rules shall be deemed to limit or otherwise affect the inherent powers of the court.
At the end of the day, it's not so important, significant document.
My lord. It is practice and procedure. These are all.
We have now Order 47 को connect कर दिया and civil proceedings, civil procedures court के साथ. So these are not, I mean, these are not like ironclad things, but we cannot, we'll see where the justice of the cause lies, and of course it doesn't mean they're totally irrelevant, so we will see when it's appropriate. It may be case, it may be bad case, I don't know. So are you conclude या कुछ और रह गया?
My lord, I have concluded.
Attorney General, if I may ask a question, if you are not bound by the Supreme Court rules in terms of whatever the Supreme Court rules say, but we are bound by Act of Parliament in regard to our own practice and procedure, do you think that is a constitutionally viable position?
My lord,
then if the rules are made by the full court on the administrative side, and any particular bench can say, well, goodbye to the rules, why shouldn't that bench have the right to say goodbye to the act?
My lord, my response to that would be that both the preamble, from which we draw those salient features.
No, I think the thing is,
the independence
the Supreme Court is sitting as a court of law. What is it bound by? If it's not even bound by its own rules, why should it be bound by Act of Parliament?
My lord, the rules say
maybe that particular bench can say, well, we don't recognize section, what is it, section 6, and another bench can say, well, we recognize section 6.
My lord,
I mean, why should not your this law that you are defending,
I think
that be put in the same category vis-a-vis our own rules? If we are not bound by one, why should we be bound by the other?
As I view it, I think priority number 1 is constitution. Number 2 in scale of importance is law. Number 3 is rules. Then come regulations. Then come notifications. Then come whatever you want to instructions. So this is, in my mind, I go by that approach. I may be wrong.
My lord, the rules, actually Rule 6 of Order 33 itself,
I think the constitution actually
abuse of process नहीं होगी, ends of justice को meet करने के लिए you're not.
Attorney General, the rules actually come out of the constitution, and constitution says the court has to be regulated. So I think that, in my opinion, certainly the rules regulate the affairs and we bound by them. And they might be in the trajectory starting with the constitution, law and the rules, but all of them are binding, and that's how the system works.
And my lords would also acknowledge that this is not a case where Article 199 per se has been challenged on it being violative of salient features for that matter. Of course, even if that was so, both 191 and the preamble from which the salient features flow were enacted at the same time. It is not a subsequent amendment where on Kesavananda Bharti or DBA Rawalpindi matter could have proceeded. So, when the preamble, when the constitution was being made, 199 has not undergone any amendment ever since. So therefore, my lords, my respectful submission would be that this act, my lord, be declared constitutional and the petitions be rejected to that effect, and nothing in this act in any way undermines the independence of judiciary, or nor has any externality been introduced where any other organ of the state or branch of government has been
हो जाएगा वहाँ जब ये बना था। इन बिटवीन जो फैसले हुए हैं, व्हाट इज द फेट ऑफ दोज डिसीजंस? अगर वैलिड करते हैं तो फ्रॉम दैट डेट होगा, तो फिर क्या होगा इसके बारे में आप बता दें।
They become past and closed transactions in several instances in the past where a similar situation or a situation arisen where a legal position had changed, but cases were decided or transactions had happened. The courts protected those under past and closed transactions. So that would be the effective matter which stood decide.
Can the committee not retrospectively, suppose if the law is sustained, can the committee not retrospectively grant permission? The bench was constituted, assumed as if by consent. Let's put it like that. I don't know if that's possible or not.
Stand decide.
As if by consent. Let's put it like that. I don't know if that's possible or not.
Cases which stand decided, they stand decided.
अगर हम ये भी कर लें कि अगर कोई बहुत ही ऐसा unusual केस आ जाए, I don't know.
My lord, I don't know where the line would be drawn. But in so far as
I think
जी मैं इसको भी एड्रेस कर दूंगा।
ड्यूरिंग द पीरियड की बात हो रही है ना, जो केस इस दौरान जो हुए फैसले हो गए, उनका क्या बनेगा?
सो जो केसेस लिस्ट अब पेंडिंग ही नहीं है और वो डिसाइड हो गए हैं केसेस
ड्यूरिंग दिस पीरियड
जी पीरियड, उसको अब आपको देखना होगा कि उसको आप पास्ट एंड क्लोज में प्रोटेक्ट करते हैं जो फैसले हो गए।
इतना पास्ट नहीं हुआ, अभी कई बात है
वो। आई थिंक दैट इज समथिंग दैट माय लॉर्ड वुड हैव टू
दो चीजें हो सकती हैं।
इफ माय लॉर्ड विश टू प्रोटेक्ट देम इन पास्ट एंड क्लोज
all the angles. उसमें दो possibility, that is possibility. So this is a possibility. We're just airing it. We don't know the answer.
उसमें दो चीजें हो सकती हैं। एक तो डिफेक्टिव डॉक्ट्राइन को हम देख सकते हैं, दूसरा राइट ऑफ अपील हो जाएगी। So they can, जिनके
as far as 184(3) is concerned उसकी होगी, जिनकी नहीं थी 184(3) वो तो सिर्फ बेंचेस की कॉन्स्टिट्यूशन तक रह जाएगी बात। उसमें आप देख सकते हैं कि वो तो
It won't be a classic. देखिए दो किस्म के होते हैं, एक होता है classic quorum non-judice, ठीक है? This won't fall in that category. It will be simply a procedural lapse. Whether a procedural lapse will affect the outcome,
the cases which stand
I don't know. I mean, क्योंकि एक तो होता है ना सब्सटेंटिव राइट किसी की गई, बोले आपका क्या राइट किया?
वो डिसाइड हो गए केसेस, वो पास्ट एंड क्लोज।
नहीं, पास्ट एंड क्लोज का लफ्ज क्या अगर हम कहें, देखिए एक होती है यू सब्सटेंटिव राइट हैज बीन टेकन अवे, ओके दिस 3 didn't hear it, those 3 heard it, आपको क्या फर्क पड़ा है इससे? Are you with me?
Ji.
So I'm just thinking aloud.
Understood. So it does not, let's say, there's no, it's substantially कोई offend नहीं किया किसी right को कोई. It was a matter of procedure.
और अगर कोई जैसे कहा कि कोई बहुत ही चीज हो गई ऐसे वो रिव्यू तो पड़ा हुआ है फिर भी और ये अपील पड़ी हुई है 184 में. तो
जी. And in any event, I mean, it was a bench comprising of your lordship.
No, we don't want to kind of create a situation where things don't function. So भाई वो उसको क्या पड़ेगा? जब आपने मेरा अदालत में सुन लिया या सरदार साहब की अदालत में सुन लिया, कोर्ट तो थी ना, वो तो गलत कोरम जुडिस होता है ना, गलत अदालत अब चलेगा. इख्तियार ही नहीं था to begin with. हमारे पास इख्तियार तो था. बस सिर्फ वो एक practical procedural matter that would be really for us, not for the litigant. उसको क्या पढ़ना है?
I would say, my lord, and that I think to that extent.
I don't think that it will affect the decided cases. It has become past and close.
I think that's the only fair conclusion that we can arrive at, insofar as
we're just going to take a short break. Let Qazi Saab and others and any other from the petitioner side. I see Mr. Bandari. You are for the petitioner or the?
Your lordships have put various political.
No, who are you for?
I am for PTI.
Which side of the divide?
I am supporting the petitioners, but I am also not saying that Article 191 is completely outs the powers of the Parliament.
I would really like to hear you. Anyone else from this side? Petitioner. तो अगर आप लोग articulate जरा कर लें, we'll take a short break.
My lord, I have actually filed my written submissions.
नहीं, अगर मैं कर दूँगा. Why are you depriving us the pleasure of hearing you? Unless you want to deprive us, that's fine.
No, not at all, my lord. I'm here.
चौधरी साहब भी हैं. तो and of course we won't rush it. आप अपने जवाब भी दे दीजिएगा जो आप देना चाहते हैं. And we'll just come out.
Lord, I've sought rejection of these petitions on the grounds on maintainability for failing to meet the test criteria laid down under clause 3 of Article 184, which is the matter must be of public importance, first. Second, it must relate to enforcement of fundamental rights. My Lord, my first submission on whether these petitions raise or they raise any issue or question of public importance. My Lord, my learned friends, the counsels for the petitioners, they have largely, their case is rooted in lack of legislative competence not necessarily objecting to the contents, all of them, but it's essentially rooted in lack of legislative competence of government in terms of Article 191. And the argument, my lord, is that because the powers and because this honorable court in 1980 had made rules, therefore the field stands occupied, and in any event could not legislate. My lord, firstly, insofar as public importance is concerned, my lord would have now gone through the law, and my lord would see that this law in fact deals with the concentration of powers, barring one provision, but concentration of powers in one office. What this law endeavors to do is, it democratizes this institution, brings more transparency, and structures the discretion, which is something, this structuring of discretion is something which has found favor with this court. The 7 principles enunciated in Amanullah case, PLD 1990, Supreme Court 1092.
PLD 1990,
Supreme Court 1092. Open policies, open plans, transparency, and so on, which this court has held that it is required of every, and of course it was with regards to the powers that the executive exercises. Now these are all administrative powers we are talking about. This law deals with largely, barring of course section 3. There was a question that was raised, I'll address towards the end, and section 5, which I will address separately. So insofar as public importance is concerned, this law in fact deals with the issues which are important for public, which is the litigants. Secondly, insofar as independence of judiciary is concerned, my lords, there is no external element, which is to say that no other institution which has given any role whatsoever under this act insofar as practice and procedure of this court is concerned. It is all confined within this court. And that alone suffices insofar as the lack of any basis to challenge this act on the basis of violation of any fundamental right, because Article 9, yes, Article 9 as expounded by this court, access to justice and of course independence of judiciary is something which is which every citizen of this country is entitled to. So my respectful submission insofar as maintainability is concerned, these petitions fail on both counts.